Hi, good morning. My name is Dr. Amy Zulaika, and with me today is Dr. Chai Jan Hai and also Dr. Farah Najibah. We will do a forum-style presentation for our group, and I will be the moderator. Without further ado, let me start with the introduction. Medical practice carries not only the responsibilities to heal, but also the obligation to do no harm to the patient. When a medical practitioner fails in his duty of care, it can lead to more than just a civil liability, it can also give rise to the criminal liability. Medical malpractice are usually handled through the civil court, where its breach is redressable by an action for unliquidated damages, or simply put, monetary compensation to the affected person. However, there are situations where a criminal action can be taken against medical practitioner, particularly in cases where gross negligence and recklessness is involved. Criminal action against medical practitioner is not common. It is due to the burden of proof that the prosecutor needs to establish a criminal offense which is very high, beyond reasonable doubt. In criminal liability, there are two fundamental elements that must be proven: actus reus and also mens rea. Actus reus itself means the wrongful act itself. Once there is actus reus, then the prosecutor must establish the second element of mens rea, which refers to the guilty mind, the state of mental of the accused, and it can take several forms depending on the offense. There are four mental states in mens rea: intention, knowledge, recklessness, and also negligence. The last part of the mens rea is most common in medical malpractice, where a medical practitioner fails to exercise the duty of care as a professional should. In Malaysia, all criminal liability are listed in the Penal Code, Act 574, including criminal liability against medical practitioner. For the overview of criminal liability against medical practitioner, I will pass the floor to Dr. Farah.
Yes, thank you, Dr. Amy. Now, as an overview, to provide a brief general picture, criminal liability for medical practitioner can be divided into two broad categories. The first one related to the offences listed in the Penal Code, such as negligent treatment causing death under Section 304A, voluntary act that caused a woman with child to miscarriage under Section 312, and medical treatment performed without consent, which would constitute battery, which codify under Section 350 of Penal Code. The second category of offence can be described as administrative in nature, such as offences under Medical Act 1971 for practicing medicine without a valid annual practicing certificate. Another examples of this are any offences related to the use, maintain, or sale of drugs regulated under Dangerous Drug Act 1952. That's all for the brief overview. Back to you, Dr. Amy.
Okay, thank you, Dr. Farah. There are many more provisions in the Penal Code that can be taken against a medical practitioner. However, due to the time constraint, we will only focus on 4 sections in the Penal Code. We will start our first discussion with Dr. Farah with her topic of the gross negligence. Back to you, Dr. Farah.
Yes, thank you. Now, for the first part of this presentation, we will be focusing on the topic of gross negligence from negligent act to the death of the patient. Next slide, please. In determining the criminality of medical negligence case, it is important to first differentiate between an ordinary crime to a medical crime. While both crime causing the death of a person, in ordinary crime, the main concern is the result, which is the death of the victim, while in medical crime, the main concern is the cause, which is the presence of the negligence act. Although both of the consequences are fatal, if there is no element of negligence or error, then the doctor cannot be blamed. The same view was shared with the study conducted in UK that the law must move away from an outcome bias, a stance where a patient death is required, to a conduct bias, which focusing on the causation. Next slide, please. Now, what do we think about this flowchart? Will every medical practitioner who caused death to their patient by their negligent act or treatment be criminally liable? According to Abdul Halim in his article, negligent act can be categorized as criminal if it fulfills the formulation of criminal offences, namely disgraceful act or actus reus and also mens rea. Next slide, please. Now, what is it mean by simple negligence and when simple negligence becomes gross negligence? Negligence is a breach of a standard of care that often result in civil lawsuits or for compensation. In other words, it's a negligent act under the law of tort. On the other hand, gross negligence is a negligence of high degree transcended from tort into the realm of criminal law and warrants criminal sanction. This type of negligence may cause death or bodily injury to the victim or in medical context to the patient. Next slide, please. Albert Lee, through his study cited below, studied how clinical negligence might lead to criminal proceedings and factors to be taken into consideration. In previous study by Robson in UK, 3 factors that should be considered are: first is awareness, whether the medical practitioner aware of the risk. Second is choice, whether the doctor choose to run the risk. And lastly, control, whether the said medical practitioner has the opportunity to act differently. Robson also added that the negligent act should be culpable to constitute a criminal act such as gross negligence manslaughter. Next slide, please. Now, English common law provides for an offence of gross negligence manslaughter. Example is the case of recent infamous case of Bawa Garba, where the jury contended that her negligent act was amounted to criminal offence of gross negligence manslaughter following the death of 6-year-old patient. So in this case, what actually amounts to gross negligence manslaughter? Recently, English common law has led a 6-stage test through the case of Rex against Brockton, where they provide a comprehensive summary on the 6 elements required to be proven for the offence of gross negligence manslaughter. Next slide, please. Under Malaysian law, there is no exact equivalence of the offence of gross negligence manslaughter, but the closest one is the offence of causing death by negligence under Section 304A of the Penal Code, as written in the slide. However, there is no definition of negligence under Penal Code. Next slide, please. So federal court in the case of Adnan bin Khamis against public prosecutor held that the term negligent in various offences under Penal Code, including under Section 304A, to be substantially given the same meaning as that adopted in the tort of negligence under civil law. Therefore, the act of negligence alone may be sufficient to convict the defendant whose negligence has caused the death of the victim. And the same was observed previously in the case of Anthony Sami against public prosecutor. However, it is important to bear in mind that unlike civil claim, negligence in a criminal case must be proved to be higher standard of proof of beyond reasonable doubt. Next slide, please. Now, despite this, there are infrequent application of criminal sanction in the case of medical negligence. Next slide. In Malaysia, criminal prosecution which relate to the practice of medicine are relatively rare. Chandrasari in his article mentioned that there have been a very limited number of criminal medical negligence in jurisdiction worldwide, and the reason could be most probably because the courts are reluctant to prosecute the noble people in medical profession. Next slide. And then another study conducted by Akash Sethi in India agreed to the decision of the court where a very high degree of negligence is required to be proved before the felony is established. In his study, out of 90 cases of potential criminal medical negligence, only 1 case was convicted. And this is due to the difficulty in proving the elements of gross negligence, and plus doctors are usually protected under the law for the acts done in good faith. Next slide, please. Now, as mentioned before, negligent act may cause death, but also bodily injury to the patient. The criminal action that can be taken against them are provided under Section 336 until Section 338 under Penal Code, as written in the slide. So to sum up, criminal cases against doctor following negligent act are relatively rare, including in Malaysia, due to the reasons mentioned before. And based on the view of federal court, to the term negligent under Penal Code, there is a possibility for medical practitioner who caused death or injury following negligent treatment to not only be found liable in the tort of negligence, but also be found criminally liable under those sections. But again, one must remember that to prove this, they must be proved to be beyond reasonable doubt. That is all for my presentation. Back to you, Dr. Amy.
Okay, thank you, Dr. Farah. So I will pass the next presentation to Dr. Cha Jan Hai for his topic of abortion. Please proceed, Dr.
Thank you, Dr. Amy. So for now, we'll be examining in details on the penal code provision that govern the abortion in Malaysia. Next slide, please. In Malaysia, abortion law exists in a complex legal landscape where Islamic law for the Muslim and criminal law for all citizens interact. The Penal Code criminalizes abortion except under strict exceptions, creating a significant legal risk for medical practitioners. This session will discuss on, first, the current Penal Code framework governing the abortion, second, comparative constitutional perspective, and also lastly, the needs for legal reform to protect doctors and women's rights. Next slide, please. So let's begin with the section 304 of the Penal Code, which deals with the culpable homicide not amounting to murder. This provision becomes critically important in case where an abortion procedure results in death of the pregnant woman. This section is divided into two parts, section 304A and 304B. Under section 304A, if a doctor performs an abortion with intention to cause death, or with the knowledge that it will likely cause death, they can face imprisonment up to 30 years and shall be liable to fine. Now you may ask, when would this apply? Consider a scenario where a doctor knowingly used unsafe methods or performed the procedure in dangerously unhygienic conditions. Section 304B covers a situation where death is caused by an act done with the knowledge that it is likely to cause death, but without any intention to cause death. The punishment here is imprisonment up to 10 years, or with fine, or with both. An example would be improper administration of local anesthesia by an obstetrician during an abortion procedure led to patient's death. Now, moving on section 312, this is the primary provision that criminalizes abortion in Malaysia. The section states that whoever voluntarily caused a woman with child to miscarry shall be punished with imprisonment for a term which may extend to 3 years, or with fine, or with both. And if the woman is quick with child, shall be punished with imprisonment for a term which may extend to 7 years and shall also be liable to fine. However, this is crucial. There is an exception. The provision does not apply if the abortion was done in good faith to save the woman's life. This exception has been subject to significant judiciary interpretation. Now it comes to section 313, which dealt with causing miscarriage without the woman's consent. This is an aggravated form of the offense under section 312. The punishment here is much more severe, imprisonment which may extend up to 20 years and also liability fine. Next slide, please. Section 314 comes into play when death results from an act done with intent to cause miscarriage. The punishment here is imprisonment up to 10 years and also liability to fine. If the act is done without the consent of the woman, imprisonment may extend to 20 years. This differs from section 304 in that it specifically addresses death resulting from abortion procedures. In practice, this section is often charged alongside with section 304. The prosecution must prove that the act was done with the intent to cause miscarriage and that this act resulted in death. Section 315 criminalizes act done with the intent to prevent a child from being born alive or to cause it to die after birth. The punishment here is imprisonment up to 10 years or with fine or with both. So, having walked through this provision, several key observations emerge. First, our Penal Code takes an extremely restricted approach to abortion, permitting it only to save a woman's life. Second, the punishments are severe, particularly for violation of section 313. Third, as we've seen from the case law, there are significant challenges in applying this provision to real-world medical scenarios. This framework creates what I would call a chilling effect on the medical practice, where doctors may hesitate to perform even medical necessary procedures for fear of criminal liability. As we will discuss in our next session, this has led to calls for reform from both the medical and the legal communities. Next slide, please. Now, let's turn on our attention to examine how other jurisdictions have addressed similar changes in this topic. Next slide. As we transition from examining Malaysia's domestic legal framework, it becomes imperative that we situate our understanding within global cooperative perspective. Today, we will analyze how different jurisdictions balance the same complex interplay of medical ethics, criminal law, and social values that we have been studying in Malaysia context. The Indian Supreme Court landmark on 2022 judgment in X against Principal Secretary in Health and Family Welfare Departments established abortion access as a fundamental right under the Article of 21, guarantees the personal liberty, building on justice of K.S. Butta's Swamy against Union of India on bodily autonomy. The court held that reproductive autonomy includes the right to make decisions about one's body. The 24-week limits under the Medical Termination of Pregnancy Act must yield to fundamental rights in exceptional case. Marital status cannot be the barrier to access as artificial distinct between married and unmarried women, violating Article 14, the rights to equality, overturning prior discriminatory interpretations. While our court has been reluctant to constitutionalize abortion's right, India jurisdiction has actively transformed statutory protection into fundamental rights through the progressive interpretations. Meanwhile, let's look at Section 12, Subsection 2, Paragraph A of South African Constitution, which explicitly guarantee the bodily integrity which their constituted court in the Christian Law Association help encompass abortion's right. Their choice on termination of pregnancy act permits the abortion on request up to 12 weeks and allow abortion up to 20 weeks for broad social or economic grounds. And they only require one doctor's approval for that. Now we look at the legislative approach in Muslim majority states. Under the key 1983 population planning law, abortion is permitted up to 10 weeks without restrictions, while allowed later abortion for health indications. In Indonesia Health Law 2009, abortion for rape victims is permitted within 6-week gestation as well for fetal abnormalities with 2 doctors' approval. So, such a practice demonstrates how Muslim majority nations can create exceptions while maintaining religious sensitivities. On the other hand, you can balance between the access and regulation for abortion. The Abortion Act on 1967 as amended states that abortion is permitted up to 24 weeks on broad health or social grounds with those with after 24 weeks, only for severe fetal abnormalities or life risks. Only 2 doctors' approval are required for the procedure, and the Act also includes conscience clause for objecting providers. Meanwhile, Canada takes a bigger leap with discriminating approach. Following the R.V. Morgentaler case, it has struck down the Section 251 of the Criminal Code, full reproductive autonomy balanced by their professional standards. Next slide, please. So, should Malaysia consider specific legislation to clarify the legal boundaries for medical practitioners in abortion case? To begin with this discussion, we might reflect on how current law may unintentionally contribute to difficult realities. Due to Malaysia's high restrictive law, an estimated about 98,000 unsafe abortions occur annually as women resort to dangerous back alley procedures. This black market flourishes because legal abortions are virtually inaccessible except in immediate life-threatening cases. The human cost is devastating. Unsafe abortion account for approximately 10% of Malaysian maternal deaths, according to the Ministry of Health data. The mortality rate from this unsafe procedure is 23 times higher from that legal, medically supervised abortion based on WHO findings. Next slide, please. Our current penal framework is fundamentally mismatched with medical realities. Criminal law cannot adequately address the complex ethical decisions healthcare providers face daily. We need a dedicated medical termination pregnancy act that 1. Define clear exceptions, such as for rape, incest, fetal abnormalities, and mental health risks. 2nd, establish gestational limits based on medical evidence. And also lastly, replace criminal penalties with professional medical regulation for licensed practitioners. The evidence is clear. Legal reform saves lives. Singapore has close to 0 abortion-related deaths since their legalization, and Thailand saw maternity mortality drop up to 62% after decriminalizing early abortions. while the UK 1967 Abortion Act demonstrates how clear regulation protects both the patient and also the doctors. Hence, Malaysian law must evolve to reflect medical ethics and save life. This isn't about promoting abortion. It's about preventing needless death from unsafe procedures and protecting doctors' ability to provide ethical care. Remember that the measure of any legal system lies not in its theoretically consistency, but in its ability to deliver just outcomes in real-life people. The reform we have discussed today offer a path for reduce unnecessary suffering, respect religious value, protect medical practitioners, and uphold constitutional principles. With that, thank you. Now I'll pass the floor to Dr. Amy.
Okay, thank you, Dr. Chai, for the presentation of abortion. All right, so for my topic today, I will discuss two sections in the Penal Code. The first topic will be the medical treatment without consent. In medical practice, obtaining a medical consent before a procedure is mandatory, and it is a legal and ethical obligation to the patient. Failure to do so may constitute as a battery, which is a form of trespass to the person under the civil law. This is established in Malaysia through the leading case of Fiona. The federal court in this case emphasized the importance of informed consent, highlighting a duty of care to inform the patient not only about the procedure, but also the potential risks and complications. While the civil court recognized this as a battery, the penal code refers this medical malpractice as a criminal force, where under the section 350 of the penal code, even if it is a medically intended, if done without consent, it can be said to use criminal force. This is the section 350 in the penal code. Whoever intentionally use forces to any person without that person's consent in order to cause the committing of any offense or intending by the use of such force illegally to cause or knowing that it is to be likely that by the use of such force, he will illegally cause injury, fear or annoyance to the person to whom the force is used, is said to use criminal force to the other. All right. Apart from the section 350 of Penal Code, a medical practitioner can also be held liable under section 321 and section 322, voluntarily causing hurt and voluntarily causing grievous hurt, when the results of such medical treatment above results in the grievous hurt to the patient. An article by Anastasia Ezra analyzed the legal framework and defenses against medical practitioners in 3 countries, Malaysia, Indonesia, and Arab Saudi, related to informed consent. Informed consent in Malaysia are regulated by the Medical Act 1971 with its subsidiaries, whereas in Indonesia governs this matter under Medical Protection Act 2009 and Indonesian Penal Code. For Arab Saudi, who practices Islamic Sharia law, informed consent is regulated by law of practicing health profession by royal decree and also guideline, where the legal implication for informed consent can be civil and also criminal. Although this article demonstrates statutory provisions and legal defenses that covers criminal liability for medical practitioner, the author recommends a special court or new specific legislation for medical malpractice. It is equally important to highlight the defense provision available to protect a medical practitioner when the act is done in good faith. This is to ensure that the medical practitioner doesn't practice defense medical. So in section 88 of the Penal Code, an act is not an offense if it is done with the patient's consent in good faith and for the person's benefit, provided there is no intention to cause death. So even if the results is unfortunate, when it is done in good faith and with the consent, the act is not an offense. All right. The next section in Penal Code that covers the administrative nature of medical malpractice is codified in section 401, which criminalizes presenting a forged document as genuine. This includes a forged qualification, falsified certification, or other medical documents. In Indonesia, similarly, criminal liability for malpractice in administrative nature falls under the Indonesian Penal Code, as mentioned by an article by Benny Satria. Although most of the cases are handled through the disciplinary channel rather than criminal prosecution. Recent reports in the Straits Times by Shafiq Al-Khatib highlight the tangible consequences of administrative misconduct for medical malpractice. In this case, a medical practitioner was sentenced to 4 months jail for forging 4 certificates of competency to use for application of license to practice aesthetic medical practice. This case underscored the serious legal ramification for practitioners involved in falsifying credentials of administrative documents, directly impacting the public trust and patient safety. So for our conclusion today, the legal landscape surrounding medical practice in Malaysia, governed primarily by the Penal Code, Act 574, necessitates meticulous adherence to the legal and ethical standards. It is our opinion the current legislation of Penal Code and Medical Act 1971 with its subsidiaries are adequate in governing medical practitioners in Malaysia. Although there are many numerous provisions in the Penal Code addressing medical malpractice, there are also statutory defense available. As we conclude, remember that the measure of any legal system lies not in its theoretical consistency, but in its ability to deliver just outcome in the real people's life. The reform we discussed today offer a path to reduce unnecessary suffering, respect religious values, protect medical practitioners, and uphold constitutional principle. This is the bibliography of the table of cases, table of legislation, also table of secondary resources. With this, I end our group presentation. Thank you very much.